Excellent. So again, welcome. The Office on Violence Against Women is convening this pre-application session to go over the fiscal year 2024 solicitation for the Legal Assistance for Victims, or LAV, grant program. The purpose of this session is to provide information regarding the LAV solicitation. We'll highlight a few key points in this presentation. However, it's not the intent, nor is there sufficient time to go over every aspect of the solicitation. All applicants are responsible for reading the FY 2024 LAV solicitation and the OVW solicitation companion guide, and ensuring that a complete application is submitted. LAV program staff cannot provide any feedback to applicants about the quality of an applicant's proposal or provide any information outside of what's presented in the solicitation. However, we are available and will be available throughout the period that the solicitation is open to respond to any questions about application requirements. Please feel free to send questions about the LAV solicitation to the LAV program email box at ovw.lav@usdoj.gov or call the main line at 202-307-6026. We'll also pause periodically throughout this presentation to answer your questions live. So please do feel free to keep those coming in the Q&A box. It will be helpful to have the LAV solicitation in front of you for a point of reference during this information session. You may take a moment now to open it if you've not already done so. Also, we will be posting these slides after the webinar, so please don't feel that you must remember everything that we tell you here. You may use the presentation alongside the solicitation and the companion guide as you prepare your application. Finally, please note that there was a separate presentation discussing the LAV grant program's Expanding Legal Services Initiative yesterday. ELSI, the Expanding Legal Services Initiative for short, is intended to assist organizations that don't currently offer in-house legal services by providing them with resources and funds to establish a legal program. If you're interested, the recording from that webinar should be up on the OVW website shortly. Next slide. On the cover of the solicitation, please note that final applications are due by 8:59 p.m. Eastern Time on Thursday, February 15th. Please refer to pages 30 through 32 of the solicitation for more information on submission and intermediate deadlines. OVW will not accept late applications, so applicants are strongly encouraged to begin submitting their applications 48 hours prior to the application deadline and to carefully review the OVW policy on late submissions, which can be found on pages 31 through 32 of the solicitation. Finally, OVW anticipates notifying all applicants of funding decisions by October 1st, 2024. Eligibility is mentioned briefly on the cover of the solicitation, as well as in more detail on pages 12 through 13. Eligible applicants include private nonprofit entities, publicly funded organizations not acting in a governmental capacity, such as law schools, territorial organizations, Indian tribal governments, including Indian tribal consortia, and tribal organizations. Page 6 of the solicitation provides background on the history and goals of the LAV program. LAV is intended to increase the availability of civil and criminal legal assistance needed to effectively aid victims ages 11 and older of domestic violence, dating violence, sexual assault, and stalking. The LAV program provides funds for comprehensive direct legal services to victims in legal matters relating to or arising out of that abuse or violence. Comprehensive legal services should address the broad spectrum of legal issues that victims encounter. In addition to representation in emergency and non-emergency protection order hearings, this includes representation in family matters, So divorce, child custody, child support, consumer and housing matters, and credit restoration, among others. Services must include legal representation by a licensed attorney, with one exception, which I will note in just a moment. In addition to an attorney, legal assistance may also be provided by some other qualified professionals, including BIA accredited representatives in immigration proceedings, VA authorized representatives in VA claims, or anyone who functions as an attorney or lay advocate in tribal courts. Finally, and this is the exception, applicants who plan to provide services only in tribal courts may propose projects that only include lay advocates who are authorized to provide representation in those courts. These applications should detail the allowable scope of representation that lay advocates will be allowed to provide in the tribal court where victims will be represented. Any services unrelated to the provision of legal assistance or legal advocacy are unallowable under the LAV grant program. However, examples of activities beyond direct legal services that may be supported with LAV funds include advocacy, as long as the advocate is providing services related to the legal assistance. For example, safety planning, court accompaniment, and preparation for court appearances. Translation services, if these are directly related to the legal services. Childcare, that's directly related to legal assistance. For example, childcare to enable the victim to meet with their attorney to go to court, or I should say, or go to court. And transportation, that's related to the legal assistance. For example, travel to meet with the client's lawyer or to go to court. Please note that LAV funds may not be used to provide criminal defense services. However, funds can be used to provide post-conviction relief to survivors if the matter is relating to or arising from domestic violence, dating violence, sexual assault, stalking, or sex trafficking. If you or a project partner provide services that are unrelated to legal services, you should make it clear in your proposal that LAV funds will only be used to support allowable activities. All right, funds under this program must be used for one or more of the statutory purpose areas listed on this slide. The fiscal year 2024 LAV grant program has 3 purpose areas. You'll find this information on page 7 of the solicitation. Please review this section carefully, as project activities funded through the LAV grant program must fall under one or more of these purpose areas. You will note that purpose area 3 in particular states, quote, not more than 10% of the funds awarded may be used for pro bono legal assistance. This requirement applies to the entire amount of LAV funding appropriated for the year. So this is something that we at OVW monitor internally. Applicants, so you all, are not required to limit your proposals to 10% pro bono legal assistance. This is a question that comes up a lot, so we just want to address it from the get-go. In 2024, OVW is interested in supporting the priority areas identified on this slide and also on pages 7 through 8 of the solicitation. Applications proposing activities under these priority areas will be given special consideration. Please note that to be considered under the first priority area listed, the lead applicant must have a demonstrated and distinctive history of using culturally appropriate and linguistically specific strategies to serve communities that have been historically marginalized and face barriers to accessing mainstream systems and service providers. More information on this and on all of this is included on page 8 of the solicitation. Next slide, please. OVW recognizes the need to address the lack of available direct legal services for survivors of sexual assault and the unique aspects of sexual assault trauma from which survivors must heal. Applicants proposing to focus 50% or more of their grant-funded activities on intimate and non-intimate partner sexual assault legal services will be given special consideration. At least some grant activities must be focused on non-intimate partner sexual assaults. I should say, to qualify under this priority area, at least some activities must be focused on non-intimate partner sexual assaults. And the lead applicant or a project partner must have the mission or purpose to serve victims of sexual assault. In addition, applications that are submitted by nonprofit, non-governmental, or tribal organizations whose mission or purpose is to serve victims of sexual assault and which propose to focus all of their grant-funded activities on sexual assault, including at least 80% on non-intimate partner sexual assault legal services, can apply for larger awards and may be eligible for an additional 24 months of non-competitive funding. Recognize that that was a long sentence and a lot of details, so please feel free to ask follow-up questions in that Q&A box. In both cases, so if you're applying under this sexual assault priority area, applicants should articulate the specific legal needs of sexual assault survivors within their communities and how your project activities would meet those specific needs. Applications should also reflect the applicant's specialized training and experience in legal matters specific to sexual assault. You should demonstrate a commitment to addressing sexual assault and clearly show that you have the capacity to address the priority effectively. On that note, in order to be considered for the sexual assault priority area, applicants must respond to all of the sexual assault priority questions in the project narrative and memorandum of understanding or memorandum of exemption sections. More on this later. These additional questions are required whether you're applying to use 50% or all of your funds to serve victims of sexual assault. Pursuant to the LAV statute, at least 3% of funds made available for the LAV program must be used for projects that assist adult and youth victims of domestic violence, dating violence, stalking, and sexual assault on lands within the jurisdiction of an Indian tribe. Applications proposing to assist such victims will receive special consideration in order to meet this requirement, but they must include the percentage of proposed activities that will support services to victims on tribal lands. This information should be included in your summary data sheet, which you'll hear about more later in the presentation. OVW does not fund activities that jeopardize victim safety, deter or prevent physical or emotional healing for victims, or allow offenders to escape responsibility for their actions. Please refer to the OVW Solicitation Companion Guide for additional details on these activities. Applications that propose any activities that compromise victim safety and recovery or undermine offender accountability may receive a deduction in points during the review process or may be eliminated from consideration entirely. And with that, I'm going to turn things over to my colleague, Maria Flores, to take us through the next set of slides. Maria?
Good afternoon, everyone. Thank you for being here. We are happy to be with you today. My name is Maria Flores, and I am a program specialist at OVW. And I will be taking you through the next couple of slides here. Let me just get my screen up. And let's see here. I'm trying to navigate 3 screens here, so. All right, okay, so we are going to begin with the LAV specific out of scope activities. And I'm sorry, give me 1 second. Oh, okay, so the LAV program has specific out of scope activities that will not be supported by this program. We have highlighted some of these activities in this slide, but a couple of examples include providing representation in tort cases and developing or hosting training at the community or state level. A complete list of out-of-scope and unallowable activities can be found on page 9 of the solicitation, and a complete list of unallowable costs can be found on pages 23 to 24. It is important to review these lists thoroughly, as applications that propose activities deemed to be substantially out of scope may receive a deduction in points during the review process or may be eliminated from consideration. Okay. The federal award information, the solicitation provides details on the federal award information, and that begins on page 10. All awards are subject to the availability of appropriated funds and any modifications or additional requirements that may be imposed by law. There is no guarantee that funds will be available in the future. However, OVW may elect to make awards in a future fiscal year for applications submitted under this solicitation, but not selected for fiscal year 2024 funding, depending on the merits of the applications and the availability of funding. The award period is for 36 months and generally begins on October 1 of the following year, which is 2024, fiscal year 2024. So on the solicitation page number 11, you will find the award amounts, and the LAV program is making awards for $750,000 or $900,000, but amounts may vary. All awards will be made as grants. So applications submitted by sexual assault coalitions or nonprofit organizations whose mission or purpose is to serve victims of non-intimate partner sexual assault, and that are proposing to focus all of the project's activities on legal services for victims of non-intimate partner sexual assault, may request up to $900,000 for the entire 36-month period. Please note, if funded at the end of the 36-month award period, these grantees may be eligible to receive 24 months of additional non-competitive funding to continue their projects. All other applications may request up to $750,000 for the entire 36-month period. Again, OVW has the discretion to award grants for greater or lesser amounts than requested, and to negotiate the scope of work and budget with applicants prior to the award of a grant. Be sure to request the full amount of the award. Applicant types, if you're following along in the solicitation, it's pages 11 through 12. The LAV program accepts applications from 3 types of applicants: new applicants, continuation applicants. So for new applicants, it falls under organizations that have never received direct funding under the LAV program, or whose previous LAV program funding expired on or before 15 February 2023. Continuation applicants are organizations who have an existing award under the LAV program or an award that closed after 15 February 2023. Recipients of a fiscal year 2023 LAV award or fiscal year 2022 award that was for 36 months are generally not eligible to apply as the lead applicant on this year's proposal, fiscal year 2024. However, recipients of an FY 2022 or 2023 award may apply as the lead applicant if the fiscal year 2024 LAV application is for a distinct office that does not serve the same geographic area as the office that received funding in fiscal year 2022 or fiscal year 2023. Okay, continuation application note. Current grantees with the substantial amount of unobligated funds remaining as of March 31st, 2024, without adequate justification may be removed from consideration for funding or may receive a reduced award amount if selected for fiscal year 2024. Applicant types continued. We have the third type of applicant is a non-competitive applicant. So we have new applicants, continuation applicants, and the third type is non-competitive. These organizations have an existing award that addresses the LAV grant program sexual assault priority by focusing 80% or more of their grant-funded activities on legal services for victims of non-intimate partner sexual assault. Organizations that are eligible for non-competitive funding have already been contacted by the LAV unit by mail. If this describes your organization, please note that you should very carefully review the solicitation after this webinar, as some of the application requirements we referenced today are different from those that non-competitive applicants should follow. And now we're going to take a break for some questions, and we will pause, and we have a lot of questions. I don't know if we'll get through all of them at this break, but we have subsequent breaks to answer, to follow up.
All right, thanks, Maria. So I'll be sharing some of the questions out loud that were added to the Q&A box. Thank you so much for all of your thoughtful questions. Please keep them coming, and we'll call on my colleague, Sandy Van Orden, to help us answer some of them. All right, so first off, can we apply for both this grant and the ELSI grant at the same time? We have two offices, and we would like to use the ELSI grant for one of them and the LAV grant for the other office, or possibly both.
As long as you meet the eligibility requirements for ELSI and LAV, you can apply to both programs. However, you'll note in ELSI that we do say that an organization would not receive funding under both programs.
Excellent. Another great question. Can you define the difference between legal assistance, legal services, and legal advocacy?
So legal assistance and legal services are generally going to be kind of interchangeable terms that are going to include the broad spectrum of legal services, including representation by an attorney, representation by a tribal lay advocate, representation by a Board of Immigration Appeals accredited representative, and legal advocacy by a non-attorney. And legal advocacy, generally when we're talking about it in this context, is going to be advocacy that is conducted either by a non-attorney, or an attorney may provide legal advocacy where they're not representing a victim specifically in court, like in a civil proceeding. Maybe they're the advocate for the victim to help them through the criminal prosecution against the offender.
All right. Next up, can a partnership with a district attorney's office sexual assault unit qualify a legal services applicant for prioritization as a sexual assault focused project, even if the DA's office does not request funding for its participation?
So I kind of marked this because I think I would like the individual who put this question in to provide a little bit more detail. Generally, you're going to want, as a legal services organization, I'm assuming that you need a partner to have an organization with a mission or purpose. And that requirement is that it would be a nonprofit. Organization with the mission or purpose to provide services to victims of sexual assault. A district attorney's office is not going to be a nonprofit for those purposes. So if I'm missing something in your question, please make sure to include a follow-up.
Great. Next we have, can a program only provide pro bono domestic violence services?
I'm reading this question one of two ways. One is, can our program focus solely on providing services to survivors of domestic violence? Yes. The other way this question could be read is, can we only provide services, pro bono services for domestic violence? And that would be no. You could provide services for domestic violence, sexual assault, and or stalking.
Excellent. A follow-up, I think, on a question that we addressed just moments ago. How would you define the difference between legal services and pro bono legal assistance?
Right. So when we talk about pro bono assistance within the legal assistance for victims solicitation, we're talking about services that are provided on a voluntary basis by an attorney who is not receiving compensation. So if you have a pro bono component to your program, that is where you are working with attorneys who are volunteering and they are not being compensated for their work.
Excellent. And just as a reminder, I see a couple of messages coming through in the chat. Please ask all questions in the Q&A box so that we can keep track of them from our end. So if you would like an answer to your question, please type it into the Q&A box. Thank you. All right, that said, question from a current LAV grantee. So the question is, if we have a current LAV grant, which ends in fall 2024 for a distinct geographic area, and we have a new LAV grant approved with 2023 funding that just started in a different distinct geographic area, can we apply as the lead for a continuation grant of the LAV grant, which ends in 2024? Or should we have our partner on that grant apply as the lead?
Yes, since the project is in a distinct geographic service area, you can apply for continuation funding as the lead.
Right. Switching gears a bit, for this grant, is a project partner required?
So generally, yes. However, there is an exception. So an organization, an application must include a nonprofit organization with the mission or purpose to provide services to victims of domestic violence, dating violence, sexual assault, or stalking. You should also include an organization with experience providing legal representation, legal services. And it's possible that one organization could meet both of those requirements. And in that instance, you would not have to have a partner. But if you only meet one of them, you would need to include a partner on your application.
Excellent. So question, I'm still a bit confused as to if this grant only funds attorneys or other similarly qualified individuals. Would this grant fund only a legal advocate, for example, safety planning, court accompaniment, and preparation for court appearances, and doing preparation for court appearances? We have a temporary protection order unit that helps clients through the entire TPO process, but are not attorneys.
So LAV funds can be used to support staff like the staff you're talking about, advocates who work with survivors during the court process. However, you will also notice that there is a requirement that an attorney be included in all LAV projects, with the limited exception of projects that will only provide services in tribal courts where those tribal courts allow lay legal advocates to provide representation.
Moving on, in the priority area, it indicates that 3% of the funds need to be for tribal communities. Does this apply to all applicants? And then as a second question, are traditionally underserved populations required to be specified? Just to give Sandy a little bit of a break, I'm happy to take the first question quickly. And thank you again for all of your great questions. They're definitely keeping us on our toes. So much like that 10% for pro bono legal assistance, the 3% of funds dedicated to serving victims on tribal lands is something that we monitor internally. You as an individual applicant can apply to use anywhere from 0 to 100% of your funds to serve those victims. We just ask that you specify the percentage and you will see a spot to do so in your application. But I will turn to Sandy for that second question. Are traditionally underserved populations required to be specified?
So you'll notice in the purpose of the proposal section that item number 1 includes describing the communities in the service area, including but not limited to those traditionally underserved populations within the service area of your project.
Excellent. All right, we are getting on through these slowly but surely. What is the definition of non-intimate partner sexual assault per this grant?
So non-intimate partner sexual assault would be any sexual assault where the offender is not an intimate partner of the victim.
Sorry for the slight delay on that. And well, great segue. This individual joined late and they apologize if we answered this already. If we're applying under the 50%, I assume that you mean under the 50% sexual assault priority, that is dedicating 50% rather than all of your funds to sexual assault legal services. Are we required to fill out the additional questions specific to the priority area?
Yes, any any competitive applicant who is applying under the 50 or 100% sexual assault priority area needs to include all of those questions. Non-competitive applicants aren't going to answer the same questions in the purpose of the proposal section, but all applicants addressing sexual assault should generally include the answers to all of the sexual assault priority questions.
All right, I think we're just going to do a few more and then carry on with our prepared remarks to make sure that we cover all of the material that we need to. So can we use this grant to hire and pay for an attorney to provide services to DV survivors in family court issues?
Yes, LAV funds can be used to pay for an attorney who will provide services to DV survivors in family court.
And conversely, these questions work well together. Instead of hiring a lawyer onto our staff, would we be able to go into contract with a lawyer instead?
Yes, it is allowable to use a contract attorney instead of a staff attorney for LAV.
All right, and one final question for this round. Do we have to have established on-staff legal representation in order to be successful with this grant? We're planning to hire an on-staff attorney for the first time. Does it make more sense to apply for LAV and include attorney salary in the application, or should we apply for ELSI?
So you could apply for either. If you are hiring an attorney for the first time to set up legal representation, what ELSI would do is you would have a planning period where you would receive training and technical assistance to help you set up that legal representation program. if you apply under LAV, you will not have that planning period. And it doesn't include the same level of mandatory training and technical assistance in order to set up the legal representation.
Excellent. Thanks so much again for all these questions, and thanks, Sandy, for providing all those wonderful answers. As one additional reminder, please do not use the chat box to submit your questions. If you would like them answered, please instead type them into the Q&A box, even if you had already submitted them into the chat box. And with that, I'm going to turn things back over to Maria.
All right, thanks, Hannah. Okay, we're gonna move things right along, and for the next slide, we're talking about the required partnership. Following along in the solicitation, we're on pages 14 through 15. The solicitation details other program eligibility requirements. Again, this starts on page 14. Each application must include a nonprofit, non-governmental or tribal organization or designated division program with the mission or purpose of providing direct services to victims of domestic violence, dating violence, sexual assault, and/or stalking, either as a lead applicant or partner. The organization serving as the required expert on these crimes may be a larger multi-service organization that does not solely address domestic violence, dating violence, sexual assault, and/or stalking, but has a distinct or designated division or program that focuses on serving victims of these crimes. As an example, this could be a YWCA that has a distinct domestic violence shelter. Each application must also include a nonprofit, non-governmental tribal organization or tribal government or designated division program with experience and expertise in providing legal representation by an attorney to victims of domestic violence, dating violence, sexual assault, or stalking. Applications where neither the lead applicant nor a partner has the required expertise will be removed from consideration. The delivery of legal assistance certification is a letter that must be included with every application. Details may be found on page 14 of the solicitation. Application and submission information is included, and it begins on page 15 of the solicitation. The complete application package is available on grants.gov or at the OVW website. Applicants wishing to request a paper copy of the application materials should contact ovw.lav@usdoj.gov. You can also give us a phone call, and we will copy and paste the email address and the phone number in the chat for you. Our phone number is 202-307-6026. Applicants should anticipate that failure to submit an application that contains all of the specified elements will negatively affect the review of the application and may result in the application not being considered for funding. It is a responsibility of the applicant to ensure that a complete application is submitted by the deadline. OVW will not contact applicants for missing items. Applicants should refer to the chart on page 37 of the solicitation to ensure that all required steps and deadlines are met. Applicants should only submit documents that are specifically asked for in the solicitation. Providing information that was not requested, such as letters of support from other organizations in your community or service area, does not increase the likelihood that an application will be selected for funding. So if you're in doubt, leave it out. Formatting and technical requirements. Please carefully review the formatting and technical requirements on page 16. Points may be deducted for applications that do not adhere to the formatting and technical requirements. Please read the entire list of the requirements. And we have some listed here. And keep in mind that the LAV solicitation is a very competitive application, and attention to detail is imperative. We're continuing with application requirements, solicitation page number 17. Applications must include the following documents. We have proposal narrative, the budget detail worksheet, and the memorandum of understanding, or MOE, memorandum of exception. In terms of the proposal narrative, this section must include the purpose of the application, what will be done, and who will implement the project sections. You can refer to pages 18 to 22 of the solicitation for complete details. The budget detail worksheet and narrative must include a budget and budget narratives that clearly links to the project activities specified in the proposal narrative. The budget should not contain items that are unsupported by the proposal narrative. You should include your budget as an attachment to your application. There is a sample budget included as an appendix to the solicitation, and a webinar on creating budget is available on our OVW website. The memorandum of understanding, or memorandum of exception, please clearly review the distinction between the two and identify which is required for your organization. Applications that do not include all of the required components will be considered substantially incomplete and will not be considered for funding. We will not contact applicants for missing documents. Please note that there are additional questions in the project narrative and MOE if an application is addressing sexual assault. Data requested with the application, there are 3 sets of questions. You have the pre-award risk assessment, applicant questionnaire, and the summary data sheet. You will complete each as a survey directly in JustGrants. These are not scored, but they are required. They are a required element of your solicitation application. At least a list of the questions for each item is included on pages 52 through 60 of the solicitation in the appendices. The proposal abstract, although this section will not be scored, your application should include an abstract that does not exceed 2 pages, double-spaced. This section should not be a summary of past accomplishments. The abstract will be entered into a text box in JustGrants. Applicants are strongly encouraged to use the template for the abstract on page 18 of the solicitation. Moving on to proposal narrative. This is found on pages 18 through 22 of the solicitation. The proposal narrative may not exceed 20 pages, double-spaced, and must include the required 3 sections that we mentioned earlier, which is the purpose of the application, what will be done, and who will implement the project. Reviewers will not read more than 20 pages double-spaced. So if your application is not double-spaced, reviewers will only read the equivalent of 20 pages double-spaced. The remainder of the project narrative will not be scored. Make sure that you respond to every question within each of the sections. Again, pages 18 through 22 of the solicitation addresses these points. Now I'm going to turn it over to Hannah.
Thank you so much, Maria. Give me one moment. So a budget and budget narrative are required. Oh, we actually just got a question in the Q&A about this. Applicants should include their budget as an attachment to their application. We strongly encourage you to use a spreadsheet program such as Excel or Numbers to complete your budget attachment. There is a sample budget included in Appendix A of the solicitation. Your budget must reflect 36 months of project activity It must include funds to attend OVW-sponsored training and technical assistance in the amount of $12,000 for proposals from organizations located within the 48 contiguous states and $18,000 for organizations located in the territories, Hawaii, or Alaska. Please note that this amount is for the entire 36 months and not per year. Applicants may budget expenses in excess of this amount if you would like to attend relevant non-OVW sponsored conferences or training. The budget and the budget narrative will be reviewed separately from the proposed project narrative. The budget narrative must describe each line item requested in the budget and explain all costs included in the budget, including how the costs of goods and services are determined and how they will fulfill the objectives of the project. On the next couple of slides, I'm going to focus on aspects of your application that relate to the documents that our financial team, the Grants Financial Management Division, or GFMD, reviews. More specifically, we'll discuss some items that GFMD has identified from prior year's applications that could help with expediting their review process. First, I'll highlight some items identified in the summary data sheet, which is completed by all applicants in a survey directly in Just Grants. A list of questions included in that survey appears at the end of the solicitation under the heading Survey Questions. This is included as an appendix in this year's solicitation. Specifically, two items that we'd like to discuss are the single audit response and the IRS three-step safe harbor procedure. OVW requests that all applicants provide a statement as to whether they've expended $750,000 or more in federal funds during their last fiscal year. If they have, then they indicate that and also specify the end date of their last fiscal year. However, GFMD is finding that applicants don't always include all of this information. Please ensure that this question is answered in its entirety on the summary data sheet in question number 3. Another item that we'd like to highlight from the solicitation is specifically for nonprofit organizations. If you use the IRS three-step safe harbor procedure to determine your executive's compensation, you're required to provide a disclosure letter. Page 25 of the solicitation provides further details. Note that there are 4 required parts of this disclosure letter. Please be sure to provide a response to each of these 4 parts. The next item that I'd like to discuss is the pre-award risk assessment survey, which assists GFMD during their pre-award risk assessment review for all applications. Each applicant must prepare a response to all 11 questions, and each question has multiple parts. We've noticed from prior years that applicants don't always fully answer all parts of the questions, which in turn requires GFMD to reach out to the applicant and which may delay funding decisions. Some of the most common issues that we've encountered have been, for example, question number 2, where the applicant indicates that they do indeed have internal policies, but they don't provide a brief list of topics covered in the policies and procedures. On question number 3, some applicants fail to provide a brief summary of the organization's process for tracking expenditures, and more specifically, whether or not it tracks budgeted versus actual expenditures. These are just a few examples, but in general, please make sure that you read each piece of the question, each piece of each question, and provide a full and comprehensive response. This slide quickly highlights some resources that are available as you create the budget to be submitted with your application. Over the last couple of years, GFMD has developed a detailed webinar presentation on how to develop a budget to be submitted with OVW applications. This presentation addresses some of the challenges that you may face with your budgets and provides some insight on OVW's budget review process. This webinar can be found at the link on this slide. Additionally, the OVW website has published guidance to help you prepare your budget attachment. Next up is the uniform guidance, which can be found at 2 CFR 200. Use your favorite search engine for this one. Other resources include the DOJ Financial Guide and the LAV solicitation itself. We know that this can be a lot of information to process, so if you have any questions about the GFMD information discussed, please feel free to contact the GFMD Help Desk at 888-514-8556 or by email at ovw.gfmd@usdoj.gov. All right, next up, the Memorandum of Understanding, or MOU. The MOU section can be found on pages 26 and 27 of the solicitation. For the purposes of this solicitation, the MOU is a document containing the terms of the partnership and the roles and responsibilities between two or more parties. The MOU must be a single document and must be signed and dated by the authorized representative of each proposed partner organization. Recall that an applicant must include a nonprofit, non-governmental, or tribal organization with demonstrated expertise on domestic violence, dating violence, sexual assault, or stalking as either the lead applicant or partner. Excuse me. Please note as well that there are additional requirements for applications addressing the sexual assault priority area. The MOE, or a Memorandum of Exemption section, can be found on pages 27 through 28 of the solicitation. This applies to applications from lead applicants that, as their mission or designated subdivision's mission, provide services to domestic violence, dating violence, sexual assault, and/or stalking victims. Please recall as well that there are additional partnership requirements related to experience and expertise providing legal services in particular. Applicants may submit an MOE in lieu of an MOU if you demonstrate that you have both of these sets of required expertise. Please note that all applications with project partners who will receive subawards should submit an MOU even if the lead applicant serves as the required expert in both of these required sorts of expertise. If you have any questions on this, please feel free to stick that in the Q&A box. We know this is a very common area where questions do arise. If an MOE is submitted in lieu of an MOU and the applicant does not meet the criteria to submit an MOE, the application may be removed from consideration. The applicant should carefully review the requirements for both the MOU and MOE and decide how best to proceed. Please do not submit both documents in your application. It's one or the other, only one will be scored. And as a final note on both the MOU and MOE, if your application includes a tribal government as lead applicant or partner, and you're unable to obtain one or more signatures on your MOU or MOE because the tribal council meeting schedule precludes this, you may submit an MOU or MOE that is unsigned or partially signed. In these cases, the MOU or MOE text must state the previous and upcoming dates of the tribal council meetings to demonstrate that the tribal council did not meet while the solicitation was open. If you're selected for funding, Indian tribal governments will be required to submit a signed MOU or MOE as a deliverable post-award. Pages 28 through 29 provide information about additional documents that will not be scored during the review process, but which should be included with your application. Failure to include any of these may result in your application being removed from consideration. Recipients of OVW funds must comply with applicable federal civil rights laws, which, among other things, prohibit recipients from discriminating on the basis of national origin and disability. This includes taking reasonable steps to ensure meaningful access to grantees' programs and activities for individuals with disabilities, individuals who are deaf and hard of hearing, and individuals with limited English proficiency. Applicants must include funds or describe other resources available in their budget that support activities to ensure access for these individuals. Please see page 35 of the solicitation for more information on these requirements. All right, and with that, we are going to pause for a second, but not final time, to answer some of your questions live. All right. Our first question that Sandy wishes to answer live is, if a program is receiving funding from state funding for domestic violence, a state funding source, can the program still apply for this funding?
Yes. You are absolutely eligible to apply for this funding if you also receive funding from other sources.
Great. Next, if you're a general legal services organization with a project that's focused on legal services to end sexual violence and assault, does that meet the mission or purpose requirement, assuming the funds will only be used to support that project?
So the way we describe it in the solicitation is that you need to have a unit or subdivision of your organization. So if your project is its own unit with the mission or purpose to provide services to victims of domestic violence, dating violence, sexual assault, or stalking, and you demonstrate that in your application, you would meet that requirement.
All right, next, does priority number 1, which is detailed on page 8 of the solicitation, apply only to tribal programs, or is it for applicants who have a history of using culturally appropriate and linguistically specific strategies to serve any community that has been historically marginalized? I can quickly take this question. I know it's a common one. Your second option is correct. The language of the priority is advanced equity and tribal sovereignty. This language applies across OVW. It does not mean that you as the individual applicant need to necessarily serve tribal victims. It does mean that you need to have that history that you've described and is described in detail on page 8 of the solicitation. Juliana, I believe that you had the same question as well. So hopefully this answers your question. Maribel as well. It's a very common question that comes through. All right, next, to clarify, legal representation by DOJ partially accredited representatives are not eligible for funding?
So your partially accredited rep who is providing the services that they are allowed to provide would be funded under LAV. And as I've stated before, LAV also requires that your project include a licensed attorney.
Okay, our next question is from Nicole. What is the difference between this RFP and the other? Nicole, I'm assuming you're referring to the ELSI, or Expanding Legal Services Initiative solicitation, and this LAV solicitation. Sandy addressed that earlier. Sandy, I don't know if you wanted to add anything to that prior answer.
No, if there are further questions later, we can try and clarify if we need to.
Perfect. So Courtney asks, it has been quite a few years since we received LAV funding. Would we be a new applicant? And the answer is yes. If it's been several years since you've received LAV funding, you would be considered a new applicant. Continuation applicants include only those who are currently receiving LAV funding or those whose current LAV funding ended after February 15th of 2023. All right, next, would serving low-income individuals fulfill the requirement of serving, quote, traditionally underserved populations, or does it need to be a population that is listed in the solicitation?
So if you look under the priority area language, and I'm getting back to that, we say that in order to receive special consideration, the applicant must have a demonstrated and distinctive history of using culturally appropriate and linguistically specific strategies to serve communities that have been historically marginalized and face barriers to accessing mainstream systems and service providers. Oh, I'm sorry. I was looking at the information in the solicitation. Sorry, Angela. So I would use the information from the priority area to determine whether or not your project is addressing an underserved population according to, for the purposes of that priority area.
Great. Next question. An out-of-scope activity is, quote, cases involving the child protection system unless the child dependency hearing involves allegations relating to or arising out of abuse of the client rather than abuse of the children. The question is, if we want to fund a divorce and custody attorney to represent victims of domestic violence, but there's also a child protection case against the DV victim for neglect, for example, would it be allowable to represent that victim who has a cabinet case against them?
If the case around neglect is related to or arising from the domestic violence victimization of the adult victim, then yes. But if it is not, then you would not be able to do that. Not or with these funds.
All right. Next from Maeve, we are an umbrella agency that is a certified rape crisis center. Does this count as having the mission or purpose to serve victims of sexual assault for purposes of the priority area?
I assume that your rape crisis center has the mission or purpose to serve victims of sexual assault. And if that center or some other division of your organization that also has the mission or purpose to serve those victims is the part of your organization that is applying, then you would meet the definition for the mission or purpose.
All right, next, what is the test for, quote, 50% of activities dedicated to sexual assault in order to receive prioritization? Is it spending 50% or more of the funding on SA services, or is there another way to define the percentage of activities focused on SA services?
So it is that 50% of your grant funds must support direct legal services to victims of sexual assault.
Right. We are a nonprofit focused solely on providing support services to survivors of domestic abuse. Do we need a project partner to apply for this grant?
You need a project partner if you cannot demonstrate that you have experience providing legal representation to survivors. However, if you do have both the services to victims and legal representation for victims experience that you can demonstrate in your application, you would not be required to have a partner.
Great. And with that, we will move on, carry on with our prepared remarks. We will answer more of your questions at the end of our presentation in our final Q&A session. Again, thank you so much for all of these wonderful, thoughtful questions. All right, so how to apply, big question, here we go. You may find this funding opportunity on grants.gov by using the CFDA number, grants.gov opportunity number, or the title of the solicitation, all of which can be found on the cover page. The FY 2024 application submission process is a two-step process. Application materials will be submitted in grants.gov and in Just Grants. We recommend starting the application process, even just the grants.gov and just grants registration process, as soon as possible to allow time to learn the system. Please read the solicitation carefully to understand all steps required to submit an application and the time required to complete those steps. Some steps, such as obtaining a unique entity identifier or UEI number, or registering with the System for Award Management, known as SAM at sam.gov, or with grants.gov, may take several days to complete. We recommend that applicants begin these processes as soon as possible, but no later than the dates suggested in the solicitation. And with that, I'm going to hand things back to Maria to take us home. Maria?
All right, thank you, Hannah. Okay, so we are going to just forge ahead. And we're going to be talking about grants.gov. We're going to be talking about the technical aspects of submitting the application and things that have to be required, done using the different systems. So we have grants.gov, and applicants must complete the application for federal assistance, which is the SF-424 in grants.gov. The specific information required for this step is included on page 17 of the solicitation. Applicants must also complete and submit the disclosure of lobbying activities, which is known as the SF-LLL in grants.gov. So after submitting these two forms, the applicant will receive, an email notification to complete the rest of the application in Just Grants. If the applicant is a new user in Just Grants, the email will include instructions on registering with Just Grants. Okay. Continuing with Just Grants, applicants will submit the full application, including attachments, in Just Grants. If you have applied for OVW funding prior to 2 years ago, which would include most continuation grantees that are on this call, you will notice some significant changes in the application process. In the Just Grants system, applicants will enter some application information directly into text boxes and surveys and upload some documents as attachments. And as you can see on the slide, these are the major elements of the application, and this is what will be submitted in Just Grants. Some are in a text box, such as a proposal abstract. What we mean by entering in a text box, you're actually going to type it. You will see a text box on the screen and you will type the proposal abstract directly in there. That's not an attachment. The pre-award risk assessment, the applicant questionnaire, and summary data will be completed as surveys directly in Just Grants. So again, those are things that you are entering yourself in Just Grants. The proposal narrative, as well as the budget worksheet and budget narrative, will be uploaded as attachments. Those are documents that you have worked on separately, and you will upload those as the attachments. The MOU or MOE will also be uploaded as an attachment. So again, please read the solicitation carefully. In addition to these major elements, other documentation will be required for all applications or when applicable. And like we mentioned earlier, the LAV solicitation is very competitive. Attention to detail is imperative. So continuing again with Just Grants. Each applying entity will have an assigned entity administrator who is responsible for managing entity level information and assigning roles in the system. The entity administrator is also known as the eBiz POC, point of contact, designated in sam.gov. For more information on registering with Just Grants, please refer to the website, which is justgrants.usdoj.gov. I think that might be a typo. Is it Justice Grants or Just Grants? Hannah?
It is Justice Grants.
Is it Justice Grants? Okay. Okay, within 24 hours of receiving your application from grants.gov, the user submitting the application in grants.gov and the SAM eBiz POC will receive an email to register for a Just Grants account. The email is DOJ Secure User Management System, and that is known as Diamond, DIMD, and will include instructions on how to create an account. So to be sure that you receive these emails and they are not flagged as spam, which happens quite a bit, we recommend adding the URL to the trusted sender list in your email settings. Continuing with Just Grants. So we have the SAM eBiz POC at the applicant organization serves as the entity administrator and must log into Just Grants to confirm the entity's profile and add users. The user submitting the application in Just Grants serves as the application submitter. Within minutes of completing their Just Grants account registration, the application submitter and the entity administrator will receive an email from Just Grants with the link to the application that was started in grants.gov. Alternatively, the application submitter can log into Just Grants and locate the pending application in their work list on the home landing page. The application number listed on Just Grants will be identical to the 9-digit number that begins with GRANT, grant, on grants.gov. So each lead applicant must have at least one authorized representative designated on Just Grants. And an authorized representative is an individual with documented authority to sign an agreement with the federal government. Before the application is submitted, the entity administrator must log into Just Grants to review the authorized representatives associated with the organization. If an authorized representative does not have a Just Grants account, the entity administrator will need to invite them to register. And again, within minutes of being invited to be an authorized rep, the individual will receive an email from Diamond No Reply at usdoj.gov with instructions on how to create an account in DOJ Secure User Management System. Once the authorized representative receives the email and completes the steps to create the account, the authorized representative will be available in Just Grants. And once the application submitter will complete the application by entering data into web-based forms and text boxes, uploading attachments and accepting assurances and certifications. The application submitter will also need to select the authorized representative or representatives. Once all sections are completed, the application submitter will submit the application. The application submitter, the entity administrator, and authorized representative will then receive an email from Just Grants confirming successful submission of the application. The Department of Justice has made a collection of self-guided training resources, including training and virtual Q&A session on application submission. And this is available at the website. As you can see here, the URL, we will copy this into the chat box for you. And again, that will include training and virtual Q&A session on application submission so that you can further process everything that we've been saying about the submission process. And so we've mentioned this before, but the application deadline, all final applications in Just Grants are due by 8:59 p.m. Eastern Time on Thursday, February 15th, 2024. You will want to carefully review the how to apply and submission dates and time sections on pages 30 to 32 of the solicitation for applicant actions with required deadlines and for OVW's policy on late submissions.
Submitting the application components at least 48 hours before each deadline, there's different deadlines to track, will enable applicants to receive notice of a failed submission and provide an opportunity to correct the error before the applicable deadline. When it comes to duplicate applications, applicants should only submit one application per program. If there are multiple versions of an application submitted, OVW will review the most recent version submitted. Our policy on late submissions, OVW's policy on late submissions, there are several options for an applicant to provide advance notice of a delayed application. Applicants should thoroughly familiarize themselves with OVW's policy on late submissions, and that can be found on pages 31 through 32 of the solicitation. Extensions are rarely granted. Failure to begin the registration or application submission processes in sufficient time is not an acceptable reason for a late application submission. For the next couple of slides, we're going to go over some helpful tips for applicants. And these are provided so that you may improve your chances on becoming an LAV grant recipient. So please note that the list is not a guarantee, of course, that you will be funded, but rather a guide to navigate you through the OVW application process. So first tip, please read the solicitation carefully in its entirety. It is important to make sure you do not miss out on any important information by just skimming through the solicitation and focusing on how to apply section. Read the solicitation and contact LAV staff or submit your inquiry to the LAV email inbox if you have questions. Do not be afraid to reach out. We are happy to assist. We are on standby for assisting with questions in reference to the solicitation. Keep in mind that the people reviewing your application are not familiar with your organization or your work, so please write your application accordingly. It is not enough to simply state that your organization will meet the program requirements. When writing your application, you should show us how you plan to implement the requirements. Keep in mind that survivors are not one-dimensional, and neither are their needs. Your application should reflect that. Please describe how you will address the complex need of all survivors in your community, including those who may be part of a specific cultural or historically underserved group. And rather than using national data in your application, please take care to find recently collected data that's local to you, if you can. If that information is not available to you and you choose to use other data, please note that recent local data, just annotate that recent local data is not available. And helpful tips continued, please be sure that your budget can support the goals and objectives in your narrative. So being overly ambitious is not to your benefit. To ensure that your application is feasible and conveys your organization's capacity, you'll want to involve multiple members of your organization when reviewing your application. In particular, be sure that the staff writing the narrative, drafting the budget, and implementing the project collaborate. We recommend that when you upload application documents, file names should be descriptive and match the language in the solicitation. For example, include proposal narrative in the file names. Take note of all the deadlines and recall that the grants.gov deadline is just before the grants deadline. So again, just take note of those deadlines. You'll want to just be very cognizant of those deadlines. Okay, some more tips. Don't include or reference materials, including attachments, that the solicitation does not ask for. Reviewers will not look at any extra materials, meaning that doing too much may negatively impact your score. Please demonstrate your expertise by showing us what you do. in not copying and pasting language from the solicitation. We want to read about the great work you do in your own words. Do not go over the budget cap. And be very careful to follow, all formatting and technical requirements. These are not just guidelines, they have an impact on your score. Print out the final document and carefully proofread and review your application to ensure accuracy and completeness. All right, we are going to pause one final time to answer any of your questions. And here, the last slide that you see here has contact information if you have programmatic questions, financial questions, technical questions. We are here to help you be successful in writing the application. And so with that, I'm going to turn it over to our team so that we can answer some more questions for you all.
Okay, thanks so much, Maria. So I first want to note on the questions that, of course, we are answering a lot of them live, but we are also providing written typed out answers to other questions that we're not answering out loud. So if you believe that you were skipped over, it is very possible that you've received a written answer to your question. So please do check the answered tab. I think you may have also received a notification if we answered your question, but I'm not certain on that. All right, so I am actually going to start with some questions that received thumbs up from other participants, indicating that they are of special interest. So Lana Martin asked nearly an hour ago, could you please explain what is required for number 8 in the budget guidance? Lana quotes here, in a separately attached document, provide the standard salary range for staff positions included in the budget for the geographic service area, the expected salary for positions in the budget, and information on how salaries in the budget were determined. So what is required here?
So those 3 things identified are what is required. You want to identify what a standard salary range for the type of position you've identified is. So an attorney providing services in our geographic area generally has a salary range of X. This is the position that we have. This is the salary that we are including in our budget. This is how we determined that this is the appropriate salary for this position.
Great. Next question, and as a note, I see people are doing that already. If you do see a question here that you would especially like answered, please do give it a thumbs up at this point so we can prioritize it. We, as you can see, are done with our formal presentation, but are happy to try to answer as many questions as we can. We will probably not get to all of them live, but we are trying our very best. So can an applicant be awarded a new LAV and LC grant in the same year as a project lead of the LAV grant and a project partner of an LC grant for different service areas? While the answer to this question is different than you may have anticipated, LC has no project partners. So LC applicants are applying without project partners. Sandy, I don't know if you wanted to address other aspects of that question or if that's what you were thinking as well.
That is also what I was thinking. As I said earlier, LC indicates that an applicant can apply to both LAV and LC, but can only receive funding under one of the programs. However, it would be possible for an applicant to apply for LC and be funded and be a project partner on an a potentially funded LAV project.
So another question came in with a thumbs up. Would limited scope representation through over-the-phone consultations with our staff attorney be considered legal services?
A limited scope representation is a legal service.
And are victims located in rural areas that can be geographically isolated considered an underserved population or underserved community?
So again, I'm going to refer everyone back for this question, like I did earlier, to the specific language in the solicitation on the underserved priority area. And if that is a priority area you would like to apply under.
For a nonprofit organization with a specialized legal team that only does services for victims of domestic violence and sexual assault, is that enough of a specialization to not require a partner DVSA nonprofit, excuse me? Is describing the DV and SA experience and training requirements for staff enough?
So the requirement is that the organization or division or subdivision, identified division or subdivision, must have the mission or purpose to provide services to victims of these crimes. If you can demonstrate that you have a team whose mission or purpose is to provide services to victims of these crimes, and the services that they provide are legal representation, then you would qualify to submit an MOE.
Next, would you expand on the requirements of attorney oversight for legal advocacy services?
So generally we require a supervising attorney on all of our projects. And I mean, like anytime that you have advocates or other people engaged in legal advocacy, you likely want to make sure that you have someone to supervise them to make sure they're not inadvertently engaging in the unauthorized practice of law and making sure that they're following all the appropriate rules within your jurisdiction.
So under required partnership on pages 14 to 15, if the nonprofit lead agency has a mission or purpose of providing direct services to victims and has experience and expertise in providing legal representation by an attorney to victims, is bringing on another partner required? The answer to that question is easy. No, you've demonstrated, at least from what you've said here, that you fulfilled both of the required partnerships for this grant. And so you are not required to bring on another partner to be eligible for LAV.
But you may.
But you may. Right, you are not required. All right, next. Would an organization that just provides legal representation for temporary restraining orders and protective orders qualify for LAV? Or do you have to provide legal services for other family law issues, such as divorce, custody, and housing?
So you'll notice that we don't specifically say that you're ineligible if all you are doing is protection orders. However, you will notice that under the purpose of the LAV program, that the program is really designed to provide comprehensive legal services beyond only temporary restraining orders.
Does a partner have to receive a subaward?
So the determination of a subaward or a contract or how you set that up is covered within some of the financial information that we have available online. If the question is, do they have to receive funds at all? The answer is no, but you should notice that the budget section requires that you fairly compensate all of your partners for the level of work unless it is specifically stated otherwise within the MOU.
All right, we have just a few more questions that we're going to answer live that have received thumbs up. If you asked a question that has not received an answer by the time we're done today, please know that we will be typing up answers to all of the questions included in the Q&A today editing that down and posting the Q&A as a kind of FAQ document together with the recording and the slides on the OVW website. As well, you may also email your individual question to ovw.lav@usdoj.gov, and a member of our team will respond to you. All right. Does having no partner reduce our chances of receiving an award? We provide a large range of services and always had a partner in the past. Just wondering for this cycle.
As long as you meet the requirements to apply with an MOE instead of an MOU, choosing to apply with or without a partner would not impact the likelihood of you receiving an award.
An important question from Rhonda: is there one contact person who can assist with all of the registrations that must be completed? So grants.gov, SAM, just grants, etc. Or are there separate tech contacts? The answer is yes, there are separate tech contacts, and all of these are included in this solicitation. However, please feel free to reach out to us at LAV if you have general questions on any of these or are not able to locate this contact information. All right, a very popular question. Can you please define what is considered demonstrated experience providing legal representation? Is it based on length of time provided, number served, etc.?
I'm sorry, I'm trying to read the questions as you say them, and I did not see that question. Can you please?
I am so sorry. Of course. And thank you all for bearing with us as we process all of your great questions. Can you please define what is considered demonstrated experience providing legal representation? Is it based on length of time provided, number served, etc.?
I would include all of that information. I would include the information on how long you've provided legal representation to survivors, and I would include the amount, like, you know, like how many survivors did you serve in the last year, if that's if you provide legal representation. As an example, it doesn't have to exactly be that, like, but you know, like, explain the services that you provide in your application to show that you have experience providing those services.
All right, it has been mentioned several times that this is a highly competitive grant. Does it count against an applicant that another office in a different geographic area already receives LAV funds? I guess another office of the same organization, presumably. Yeah.
Not necessarily. If you can show that these are distinct projects and distinct service areas that are doing distinct work, that shouldn't be a hindrance. The issue is going to be if your project proposal makes it look like you're providing the services that you could provide under a proposal that has already been funded.
All right, I believe we have just 2 more questions with thumbs up attached to them. And again, apologies that we can't get to all of your questions. We were supposed to end at 3:30, so we're already a bit over time and we want to respect your time as well. So a question from Heather from a while ago at 2:58. If we fill out an MOE as a direct legal services provider, do we still need MOUs from any partner organizations that we will collaborate with, but will not provide direct services under the grant?
So you would submit either one MOU or one MOE. You would not submit both. So if you are going to have organizations that are partner organizations on your project that you want to include in an MOU, you would submit an MOU. If you want to apply without any specific partner organizations, and you qualify, you would only submit the MOE.
All right, from 3:35 p.m. Can you please expand on the requirement that individuals with lived experience be involved in shaping and implementing the project, particularly in the case of an established project applying for this funding?
Mhm.
Can you speak to what would be sufficient to fulfill this requirement?
I think I want to ask Julie to step in on this question.
I think unfortunately Julie has had
Oh, no.
to step
Okay.
out. So I think that it sounds like this is a question that we maybe need to do a
Mhm.
little bit of internal
Mhm.
talking about. So our answer to the question will be posted as part of our Q&A document when we post the materials from this presentation on the OVW website. Thank you. That may be, I'm just doing one final look through. I think that's our last question with any thumbs up. Thank you again for all of your questions. We apologize that we did not get to 30 of them or so, but we are very grateful for the 130 questions that came in to us today, as well as for your time and attention during this presentation. If you have additional questions, including if you have a question that you asked today that was not addressed, you can either wait for that document to come up on the OVW website, or of course, reach out to us by email at ovw.lav@usdoj.gov. I'll put our email address in the chat one more time so that you have it readily available. Thank you so much again for your time and attention, and thanks as well to all the members of the OVW team who supported today. We hope you have a wonderful rest of your Tuesday. Take care.